But you wrote an analysis piece for us based on a federal court ruling, as a district court ruling, that found that a nonviolent person who was in the country illegally, who had been arrested for having a gun, that they are protected by the Second Amendment and that their rights have been infringed on by this federal law. There's a part of the Gun Control Act, the prohibited persons section, that applies to anyone who's in the country unlawfully. Can you just give us a little bit of the background on that case in particular? What did the judge, where did they come down?
So the interesting thing about this case is it involves an individual who lives in Chicago, right? Who's just like, he's been here for quite some time, for years. He's got a job and he just wanted to have a handgun to protect himself because, shocker, he lives in Chicago.
Yeah, and it was 2020 as well, right? It was when he obtained the gun, right?
Yeah. And so like that was a time where if you didn't have a handgun, you were probably pretty stupid. So he acquired a handgun, and that is the only thing he was doing that was even remotely illegal, right? That we know of, is be here, which is something that is not a felony. And in fact, wasn't even a misdemeanor until fairly recent memory. So the question is basically consistent with Bruin's standard of if something violates or runs afoul of the plain text of the Second Amendment, it has to, it can only carry the day constitutionally if that type of restriction is consistent with the historical tradition of firearms regulation, meaning there has to be a substantial historical analog to that prohibition. So the question is there a analog to categorically denying the right to possess firearms to a nonviolent class here? Like, the particular class we're saying is people who are here either unlawfully or under a non-immigrant visa, right? That's what the law section says. And I think the court correctly pointed out that there's no historical tradition of this, and the historical laws that the government pointed to in trying to defend itself were not really analogous, because the government relied predominantly on laws covering disarmament of British loyalists. And then when you actually scratch the surface a little bit, they would disarm British loyalists, but it was repairable very easily. Like their local court could go to their local court and be like, I promise I am done being a loyalist, and that was that. Whereas here it's, oh, well, how can you get your rights restored if you're an illegal immigrant? Oh, well, we'll come here legally. Okay. And so how do you do that? Well, if you're a member, for many people, it's, wait for about 110 years. So that's the short answer is there's no way to fix it. So there really isn't a connection there.
Now we also had another gun rights lawyer, Costas Morris, who's been on the show before, write a sort of counter analysis piece to yours, where he argued that perhaps there's this similar to what the government argued in this case, but that there's a political community that you have to be a part of in order to benefit from the protections of the Second Amendment. That the people are the ones who have the right to keep and bear arms, and if you're not a member of the people, as a sort of philosophical, I guess, conception, then you're out. You fall outside of those protections. What would you say to that basic concept?
So the most glaring issue there is that the people is not referred to only in the Second Amendment context. It's referred to several times in the Bill of Rights. So in order for that to hold water, you have to answer the obvious question of, okay, well then so number one, who is the people identified in the Second Amendment? Number two, who is the people identified in the Fourth Amendment and in the other time it's referenced, I believe, the Ninth Amendment, et cetera. And so when these are all referenced, okay, which ones are different and why? So it would have to be that it's either that the other three times it's used, it means something else, right? And it's consistent for those other three times, and the case law would show that it's consistent, right? But it's different in the Second Amendment context. So the then question is, well, why? Why is it different in the Fourth Amendment context than the Second Amendment context? And that's never been explained. So that's an issue. But so
in your mind, on that point, real quick, I mean, I've heard that argument before, right? But more in response to like the collective right conception of the Second Amendment, that it's not really guaranteed to individuals, the right to keep and bear arms. It's sort of it's guaranteed to militias or state militias or something of that nature. And I've heard this argument about the people come up in that context where, we don't say that about other sections of the Bill of Rights where rights are guaranteed to the people, or protected for the people. And so yeah, what is your conception, I guess, of the people then in that sense?
So I think so you're asking what do I think the people means?
Yeah. So you're saying that the people includes illegal immigrants, people who are in the country, overstayed a visa, or they cross the border illegally, or what have you. They don't have a legal status in the United States. You're saying that does include, that they are included in the people. Like, what are the boundaries of the people in your understanding? So
you have to, in order to read the Constitution consistent with all of the frameworks that we have for analyzing First Amendment cases, Second Amendment cases, Fourth Amendment cases, you have to read it in the context of the time it was written. And so let's think about that broader context. The word citizen is used, like, I think 11 times in the original Constitution. They used different terms very intentionally. And so at the time of the founding, when these rights would have been most acutely understood, a citizen only mattered, right? Like, look, there was a lot of horrible race stuff, but I don't think we really need to drive into it. I think that you can answer the race issue with some people were not considered people, and that was wrong. And we fixed that, and we can apply those fixes going backwards, right? Because it was a dehumanizing thing. It wasn't a legal categorization thing.
Right. You're talking about like slaves being banned from owning guns, Native Americans.
Yeah. Well, and also the Constitution explicitly, define it, right? The 3/5 compromise.
3/5 compromise. Okay.
Yeah.
I got
so that's dealt with when we now understand that those are people, right? And so I think it's easy to understand that people outside of the people context is human beings. Okay. Mm-hmm. There's some people might wish that included dogs or cows or whatever, but I think we can all agree that it's all human beings are people.
Right.
So then the question of the people. Well, when the Constitution refers to citizens, it's almost always in the context of specifically holding office. And so then when you look at, well, what was citizenship at the time? Well, and there was no federal citizenship for 2 years. So you didn't have United States citizenship at the time of the founding. It didn't exist. And then when it was enshrined statutorily, guess who could make you a citizen? Any court, any common law court. So you could go to what is equivalent now, like your local magistrate, and all you had to do was say, hey, I'm a white freeholder and I've been here for 2 years. And then they'd go, cool, you're a citizen. And that's only relevant for political office. So at the time of the founding, sorry, were you saying something?
No, yeah. And so that's very, very different from how we bestow citizenship today.
Right. Because remember, birthright citizenship didn't happen until after the Civil War. Mm-hmm. So at the time of the founding, up until the Civil War, it would be the case that most people were not citizens because they would have never bothered. Right. They would have never bothered to go and get registered. Like, why would they bother? And also many of them weren't eligible to apply for citizenship in their states because they wouldn't have held land. And there's never been any question that, white commoners couldn't have guns. It was never even remotely touched on. And they were certainly, in many instances, not citizens.